Well, hello, all you happy, amazing people. I hope you are having a great start to your holidays. I myself have been really busy. I wasn't able to get to do this yesterday, even though I wanted to as soon as this dropped, because it's really amazing. This is one of the AI cases that's been going on that I've been following, and from what I can tell, I'm the only one covering these. I mean, all the other stuff that's happening, there's some lawyer on YouTube going over them, and I can't find anyone who's going over these. So even though I'm not a lawyer and none of this is legal advice, I'm going to do my best to impart that information. And so this one is against Anthropic, and they're the makers of Claude AI. And there are all these Andrea Bartz, Charles Graeber, Kirk Wallace, all of these authors. And it's a class action suit against them. And it's similar to what we've been covering with Cadre v. Meta. That's a much further along trial. It's been around the longest. It's kind of the most mature of them. But all of these are kind of going the same way. They failed in all of their claims that all these AIs are just like compressed copies of their books, or they have little bits of text from their books and they just regurgitate it out. Because that's really what you need in order to have copyright infringement. Copyright is the right to make a copy. And so what they were initially saying is that since these AIs are making copies, they don't have the right to that, and so it's a copyright violation. See how that works? Well, they basically failed in every way except one, and that is about how they got copies of the books they used for their training data. And a lot of this has had to do with an archive called The Pile, in particular, one part of it called Books 3, and this is a trove of 200,000 books. And a lot of these authors are saying, hey, you used our books without permission. And so the question is, then, if you got the books by downloading them from a pirate site or whatever, is that copyright infringement? And the answer might well be no, because of a couple of other cases. The Authors Guild sued HathiTrust, and separately they sued Google Books for basically the same thing. And in both cases, it was determined that what they did was fair use because they weren't using it for any infringing purposes. HathiTrust was wanting to make that searchable index of books. So you type in a search and it says, oh yeah, that is in this book at this page, and you can look up quotes and find out where it is. But it wasn't actually giving you copies of the books. So it was an infringement. And then of course Google Books does all sorts of analyses on them, like with Google Trends, like how often is this word used? Oh, well, in the 1800s it wasn't used much, but then in the 1980s it went up, and nowadays it's being used this much. You know those little graphs they make. In order to do that, they have to look at copies of all of these books to count up all the words and how much they've used and everything. But that's a non-infringing use. And since it's a non-infringing use, it doesn't matter how they got the books. So that's kind of where we are. What the AI companies are saying is that since the AI training process is transformative, at no point is any of the content of the books copied over into the model. The model is trained to basically learn how to read and write based on the training corpus in all of these books and websites and other bits of text that it's been given. And since that cannot be copyright infringement, then it's not copyright infringement to download it, but they're still fighting it on that basis. And what we've seen in the past is they're kind of trying to sneak back in this idea that's already failed, that an AI model is a derivative work. And so the question is now, what are these Bartz plaintiffs going to do? Because now they have to amend their complaint to take care of all of that. And this is hilarious. So here's the PDF. I'm not going to go through the whole thing, but I've got some highlighted portions of it that are just choice. They are so beautiful. Just listen to this. Just the first one under Nature of the Action here on, it's page 1 you see at the bottom. On top it says page 2 of 22. That's actually page 2 of the PDF file. So yeah, there are 2 different page numbers. I'm going to be using the PDF page number and not the one at the bottom of the page. But anyway, they say, Anthropic has built a multi-billion-dollar business by stealing hundreds of thousands of copyrighted books, rather than obtaining permission and paying a fair price for the creations it exploits. Anthropic pirated them. I mentioned this before. It's a saying among lawyers. If the law is against you, pound the facts. If the facts are against you, pound the law. If the law and the facts are against you, pound the table. That's what they're doing. This is pounding the table. And they're just gonna keep doing this. And it's gonna be so funny. Because they have absolutely nothing. And apparently they know it. Because at the bottom of the paragraph it says, an essential component of Anthropic's business model and its flagship Claude family of LLMs is large-scale theft of copyright works. And then they go on, plaintiffs are authors of an array of works of fiction and nonfiction. Anthropic downloaded known pirated versions of plaintiffs' works, made copies of them, and fed these pirated copies into its models. Anthropic took these drastic steps to help computer algorithms generate human-like text responses. And my response to this is basically going to be my response to everything, which is, so what? How does that make it a copyright violation? That's what they need to say. They need to say that there has to be some sort of link between the text they fed into the model and the text that comes out. And if you don't have that link, you don't have a copy. And if you don't have a copy, it can't be a copyright violation. Anthropic has not even attempted to compensate plaintiffs for use of their material. In fact, Anthropic has taken multiple steps to hide the full extent of its copyright theft. Copyright law prohibits what Anthropic has done here, downloading and copying hundreds of thousands of copyrighted books taken from pirated and illegal websites. And yes, this is all about them whining about not making money. Anthropic's Claude LLMs compromise authors' ability to make a living in that the LLMs allow anyone to generate automatically and freely or very cheaply texts that writers would otherwise be paid to create and sell. Anthropic's LLMs, which dilute the commercial market for plaintiffs and the class's works, were created without paying writers a cent. So basically, they're claiming that automation is a violation. That's what they're complaining about, automation. Anytime automation takes your job, that's an infringement and you should get to sue. Anytime it's a substitute, anytime something comes along that's outside of what we say should be done. But again, none of that makes a copyright infringement. Anthropic's immense success is a direct result of its copyright infringement. You see, they're just kind of assuming the infringement is there. No. They're the plaintiffs. They have the burden of proof. They need to demonstrate that there was infringement. The quality of Claude or any LLM is a consequence of the quality of the data used to train it. Yeah? So what? Again, what does this have to do with whether or not it's copyright infringement? All right, next page. Without usurping the works, and just all of the words like that they throw in. Usurping the works of plaintiffs and the members of the class to train its LLMs to begin with, Anthropic would not have a commercial product with which to damage the market for authors' works. So they took what you did, they built upon it, and they're doing the same thing a different way. That's just capitalism. That's human progress. That's what that is. They're complaining about human progress. So Anthropic's commercial gain has come at the expense of creators and rights holders, including plaintiffs and members of the class. Book readers typically purchase books. Yeah, because they're readers. Anthropic did not even take that basic and insufficient step because they're not reading the books. They're not sitting there reading the books, they're feeding it into their algorithm. Anthropic never sought, let alone paid for, a license to copy and exploit the protected expression contained in the copyrighted works fed into its models. And they do nothing to say that they should have to. Instead, Anthropic did what any teenager could tell you is illegal. Again, I'm not a lawyer, But I don't think there's any standard in the law for what any teenager could tell you. You look at the law, you look at court precedents, you look at judgments. You don't look at what any teenager could tell you. Again, just table pounding. It intentionally downloaded known pirated copies of books from the internet, made unlicensed copies of them, and then used those unlicensed copies to digest and analyze the copyrighted expression, all for its own commercial gain. Again, so what? You still have to show it's infringement. And you're not. It's just bluster and histrionics. The end result is a model built on the work of thousands of authors meant to mimic the syntax, style, and themes of the copyrighted works on which it was trained. But it is not, and has never been, a copyright violation to mimic someone's syntax, style, or themes. That has never been considered a copyright violation. They wanted to. I've been pointing this out the whole time they've been complaining. They want to claim ownership over a style. And that's ridiculous. For holders of copyrighted works, Anthropic has already wrought mass destruction. Oh, we're going with George W. Bush lingo now. It's a weapon of mass destruction. It is not consistent with core human values or the public benefit to download hundreds of thousands of books from a known illegal source. Anthropic has attempted to steal the fire of Prometheus. It is no exaggeration to say that Anthropic's model seeks to profit from strip mining the human expression and ingenuity behind each one of these works. Wow, what all do we have here? Just in this one part. Mass destruction, core human values, steal the fire of Prometheus, and no exaggeration to say that it's strip mining. All of that is table pounding. Where's the law? Where's the citations of law? Where's the precedent? Where's all the Supreme Court cases that say, yes, this is illegal, this is wrong? There aren't any, because they don't have any. All right, the next few pages are just about jurisdiction and who the parties are, a bunch of factual allegations. Let's look in where it's talking about the large-scale copyright theft. Going over to page 9, Claude, for example, has shown the capability of coherently processing an entire book at once, up to 75,000 words, and generating coherent, clearly written passages in response. These responses mimic an understanding not just of the proper ordering of words and syntax, but also higher-level themes and ideas. Claude could only develop this capability from training on high-quality prose and complex, longer pieces. Again, so what? If anything, you've just made a really good case for it being fair use, because you're admitting that they could not have done it any other way. In this way, books are especially valuable training material. As one commentator put it, books offer formal and lengthy texts which help LLMs understand complex language structures, grasp long-term context, and produce coherent narratives. And again, if anything, that just shores up their claim of fair use. Because if it can't be done any other way, then what choice did they have? You can't cut them off from it. And it's not a copyright violation because you haven't shown anything like that. Let's go over to page 13 where they say, instead of sourcing training material from pirated troves of copyrighted books from this modern-day Napster. Daddy, what's Napster? Yeah, really up to date on your references there. They could have used like Pirate Bay or something and been more recent, but yeah. Anthropic could have sought and obtained a license to make copies of them. It instead made the deliberate decision to cut corners and rely on stolen materials to train their models. They stole it! And they cut corners! Okay, but where did they break the law? Oh, this next part, this is my favorite. Anthropic has suggested that it uses the training data to learn the patterns and connections between words, much in the way a human learns. And so that's just talking about the fact that it's a neural net and how it learns and how it's in that way analogous to how human beings learn. And so they're going to take that and try to use that against them, while Anthropic's self-serving anthropomorphizing of its models is clearly misplaced. Okay, so first of all, it wasn't that, it was an analogy. But as an analogy, how good is it? Well, they say, at a minimum, humans who learn from books buy lawful copies of them, or borrow them from libraries that buy them, providing at least some measure of compensation to authors and creators. Yes, but algorithms are not humans. And according to the Copyright Office, that makes all the difference. Anthropic does not, and it has usurped authors' content for the purpose of creating a machine built to generate the very type of content for which authors would usually be paid. Yet again, so what? But notice that when Anthropic made an analogy, it was self-serving anthropomorphizing, but what they're doing, which is a vital difference between humans and algorithms, is all of a sudden valid. When they just complained about Anthropic doing the same thing. Hypocrites, man! Anthropic's Claude and other LLMs like it seriously threaten the livelihood of the very authors, including plaintiffs here, as discussed specifically below on whose works they were trained. Even if that's true, so what? That doesn't make it a copyright violation. That just makes it competition. And I'm sorry, but it really sounds to me like you're admitting that you cannot write books better than this soulless grinding algorithm cranking out text. If that's your problem, and you're seriously worrying about that being a threat to you, if you're worried about that being a competition, maybe you should work on being a better writer. Just a thought. Already, writers report losing income from copywriting, journalism, and online content writing, which are important sources of income for book authors. Yeah, and McDonald's workers are complaining that the kiosks are taking their jobs, and auto workers are complaining that robots are taking their jobs, blah, 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 blah. This isn't about that. This is supposed to be about copyright infringement. Where is it? Alright, so I guess all we're really looking at back here on page 19 from this point is the prayer for relief. They want statutory damages. They want to permanently enjoin Anthropic from engaging in this conduct alleged herein. They want pre-judgment and post-judgment interests, the cost, expenses, and attorney's fees, and further relief as the court may deem just, and they want a jury trial. Okay, so Anthropic filed an answer to it. Most of it we don't need to go through because they're just denying everything or just saying how dumb they are. Let's just go over to page 10, where we're talking about their affirmative defenses, and the first one is failure to state a claim. What have I been talking about? They haven't actually said where the copyright infringement is. They've got all sorts of histrionics about, we're going to lose our jobs, we're going to lose money, they downloaded it illegally, but where's the infringement? The second is fair use. We've talked about this quite a bit, 17 U.S.C. section 107. If what you're using it for is fair use, if it's a non-infringing use, like with HathiTrust, like with Google Books, if what you're doing is fair use, then it doesn't matter how you got the originals. As long as you're not infringing with them, then you're not breaking the law. If you're just making a public archive for the sake of posterity, you're not breaking the law. If you're making a searchable index, you're not breaking the law. If you're doing linguistic examinations of how the language changes over time, you're not breaking the law, no matter how you got the books. The third affirmative defense is they didn't have the volition required for infringement. The fourth is the lack of legal or beneficial ownership sufficient to establish standing, so they're saying the plaintiffs don't even have standing. They're claiming rights to elements of works or to works which are not protectable under copyright law. And so they mention a few different aspects here which are really important. They're based around the concept of idea and expression. You have an idea, then you come up with an expression of that idea. The expression is what you can copyright. You cannot copyright the idea behind it. So that's the idea-expression dichotomy. Merger is where the idea and expression are so just inextricably connected that it's not copyrightable, because if that's the only way to express the idea, then you can't claim a copyright on it. An example might be, if you remember that show, The Orville, that Seth MacFarlane did, which was basically his Star Trek fanfic, and you're wondering how he got away with that? Well, that's because he was using the ideas of Star Trek, but none of the expressions. So he had the idea of, hey, we're on this ship and we're flying through space and we're visiting planets and things like that. Doing that as your basic science fiction show. He didn't have any of the expressions. It wasn't in the Star Trek universe. It didn't have Starfleet. There wasn't Kirk, Spock, and McCoy and things like that. He had his own expression of it. Now, of course, there are a lot of things that are similar, but that's where you have the idea of merger. Like you have a ship that travels faster than light. And maybe it even uses warp drive or whatever. I saw the first few episodes and didn't care for it, so I don't know much about the lore of the show or what they did. But even if they had ideas like warp drive, that's merger. Because you gotta get the ship traveling faster than light. You know, having a teleporter to beam down to the planet. That's just part of the idea. And so they can't say, hey, you stole our works. Well, you can't steal an idea. He went with the idea, but he used his own expression. And then scene affair are scenes that are just so tied to the idea that you're going to have them, like space battles. You've got one ship battling another, or fleets of ships battling each other. Or you go down onto a planet and you're fighting hostile aliens and you're shooting them with ray guns. Things like that. All that's part of the genre. That's scene affair. Since that's just part of it, then that's not really part of your particular expression of it. And so it's not copyrighted. And the next one is de minimis copying, which just means you used so little of it that it doesn't matter. You use like half a sentence from a Harry Potter book. And it's clearly uniquely phrased that that's where you got it from. And you get sued for that, but it's just half a sentence out of a whole 700-page book. Well, that's de minimis copying, and the judge is going to say, no, de minimis, get out of here. Stop wasting our time. It's such a small amount that it doesn't matter. The seventh is that plaintiffs have not suffered and are not likely to suffer any injury or damages. Eighth is waiver, estoppel, and laches. And the ninth is the complained of use was authorized by express or implied license. And the 10th is they're not entitled to injunctive relief because they want an injunction to stop them doing it right now instead of waiting until the end of the case to figure out damages. They're not entitled to that because the injury is not irreparable. If whatever injury they continue to suffer while the trial is ongoing, if you can make up for it at the end with like a higher judgment, more money, then that's a reparable injury. You only do that when the injury is irreparable. Plaintiffs would have an adequate remedy at law. The balance of hardships favors no injunction, and the public interest is best served by no injunction. Next page, the 11th offense. To the extent plaintiffs establish any act of infringement, that infringement was innocent, and so you only get $200 anyway. And the 12th is constitutional damages. You're violating the Constitution. Any award of statutory or enhanced damages would be an unconstitutional penalty under the circumstances of this case and would violate due process and equal protection and other substantive and procedural safeguards afforded by the U.S. Constitution. The 13th is statute of limitations. You just waited too long and it ran out. And, of course, they have not waived any applicable defenses and reserves the right to assert and rely on other applicable defenses as they may come up. Now, what they want is a judgment in Anthropic's favor and against plaintiffs, deny the certification of any class, dismiss the claims with prejudice, award Anthropic its costs and attorney's fees to the extent permitted by law, and grant Anthropic such other and further relief as this court deems just and proper. That's what's going on with this, and this is, again, it's really the shape that all of these AI cases are taking, not just with the LLMs, but with the AI art, like against Stability AI, it's all going the same way. They are just floundering and flailing. The only thing that's really left is that they downloaded pirated copies of the books or the images or the movies or whatever it was trained on, and therefore that makes it illegal. Not quite as simple as that. So the big question everyone wants an answer to out of these suits is it like HathiTrust? Is it like Google Books? Even if you download this stuff from a pirate site, if the AI training is a transformative use, if it's fair use, then that should be legal. And they all want an answer on that, just to put a stop to all of this once and for all. And hopefully they get it, and hopefully the courts go the right way. I'll continue to keep you updated. Thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell. And of course, donate.Bogosity.tv to keep me doing what I do through thick times and thin, through the cold and the hardship of winter and chronic pain and everything else. I'm going to keep doing this as much as I can. Yes, my schedule's irregular, probably will be through the holidays. We'll just see how it goes. But thank you so very much for watching. Thank you for supporting, using whatever you can, becoming a subscriber at Patreon or Subscribestar or Discord. Just keep me going, keep me doing what I do. Thank you so very much. Until next time, stay strong and be free.